So it's getting in front of any potential issue. These are critical things. This is why you hire an attorney. Attorney acts as counsel, and this counsel prevents problems from happening, which afterwards can be far more expensive. Obviously, you're protecting the bottom line of any company, and I believe this seminar will do a great job of enhancing any company or employer's financial standing by precluding any legal issues that may come from any conduct in the workplace. So, Jessica, Attorney Childress, the floor is all yours.
Thank you so much, Ryan, and thank you, DC Chamber of Commerce, for giving me this opportunity to speak to your members today and your guests. I'm delighted to be here to talk about an issue that is near and dear to my heart: employment discrimination and harassment. These are not things that you want occurring in your workplace for several reasons, two of which Ryan highlighted. One, it's going to affect your bottom line. But two, it's also going to affect the morale of your business. And if you're a small business owner, you understand that company morale and company bottom line are critical to a successful business. You have to have some margins, and you also have to have high employee morale. So today, we are going to go into how to prevent discrimination claims and harassment claims. Knowledge is power. If you don't know, you might inadvertently make mistakes. And we're here to give you the tools to understand what is actually unlawful, what you have to do, and then what you should be doing. So without further ado, I'd like to just jump right in. I am an attorney, so of course there's a disclaimer, and I'll just read this verbatim. This presentation discusses legal developments which are intended for informational and educational purposes only. The information contained in this presentation is not intended as legal advice, and it should not be construed as legal advice. This presentation does not create an attorney-client relationship between you and me or my firm, but if you would like legal counsel, please reach out to me after the presentation is over. I will provide my contact information, and we can discuss what an attorney-client relationship looks like. So we'll be spending about an hour together. So I would like to just give you a little bit of information about me. I love to travel. I also love riding my bike. So you might see me gallivanting around DC on my bike. You also may, as Ryan has done in the past, run into me at a dog park with my dog Otis. And when I have time, I am the oldest of 4 siblings. So I am with my siblings. Today, what we're going to learn about key items to consider for inclusion in your company's anti-harassment and anti-discrimination policies. DC has recently required 2 industries to provide anti-harassment policies specifically relating to sexual harassment and also seniors living with HIV. So there are 2 specific industries that now require training. So I'll touch on that. The tipped wage industry workers have to have sexual harassment training. And also long-term care facilities have to provide their staff with information about seniors living with HIV. So we'll talk about that later on in the presentation. Other industries should provide training, and we will get into what that training should look like. I also want to discuss with you why a clear understanding of your organization's values are critical to creating a culture of anti-harassment and anti-discrimination. Culture is critical. And then I also would like to discuss what are some simple daily steps that your organization can enact to create a more inclusive culture that goes beyond simple compliance. I'm going to give you the nuts and bolts of what DC and federal law require, but I also want you to take that step forward, go beyond that baseline and create a culture of respect. I'll talk about that more intensely as we go forward. Like to know, I've told you a little bit about myself. I'd like to know in the chat what you would like to get out of today's presentation. Do you want to A, learn more about anti-discrimination laws? B, learn how to train your team on legal compliance with anti-discrimination law? Do you want to more effectively lead your team? Do you want to create a more inclusive culture within your company, or all of the above? If you would just take a few seconds and type in your response into the chat, just type A, B, C, D, or E. So let's see, Lais has said E. We have Anita, E, Natalie, B, and D. I want to know how to train my legal team. Awesome. And D, I want to create a more inclusive culture. I want to learn more about anti-discrimination laws. All right, so this runs the gamut. And we will attack all of these objectives today. So let's get started. We have a lot to cover. Who's excited? If you're excited, give me a thumbs up in the chat. Give me a smile. Give me some energy. All right, I have some thumbs up. Excellent. I have some, oh yeah, I have a, let's see, someone with a party hat, smiles. All right, let's go. Overview of anti-discrimination laws. What are they? Who has heard of the EEOC? Raise your hand in the chat, raise your virtual or a physical hand if you've heard of the EEOC. Okay, we're going to law school today. So the EEOC is the United States Equal Employment Opportunity Commission. They are the federal agency that is in charge of enforcing civil rights, specifically employment civil rights. They are tasked with enforcing one of the most important civil rights, one of the most prominent, which is Title VII of the Civil Rights Act of 1964. Title VII of the Civil Rights Act of 1964 specifically prohibits what are called protected class, or prohibits discrimination and harassment based on protected classes, protected traits, or protected categories. You might hear all of those phrases thrown around. But what that simply means is that you can't discriminate on the basis of those protected categories. They are, in Title VII, at least, they are race, color, religion, sex, national origin, age, disability, or genetic information. There are more laws that the Equal Employment Opportunity Commission enforces, but Title VII is the biggest, most prominent law that they enforce. Now, you're in DC, so there is also a local agency, which is called the DC Office of Human Rights. What is it? Well, like the EEOC, they investigate claims of discrimination, they mediate. So two parties, an employer and an employee, do not always have to go to court. There's mediation. So if an employee of your organization decides to file a discrimination claim, they can file with the EEOC or the Office of Human Rights. They have what's called a work share agreement. So they share work. If you file with one, you have essentially filed with the other. So you determine which agency you'll file with. The Office of Human Rights protects far more categories than what the EEOC protects. And so we'll go into all of those categories in just a second. But they hold hearings on discrimination claims. So like Ryan was discussing, there's a hearing where they take testimony, you bring witnesses, you provide documents. They do hold hearings to determine, is there a probable cause of discrimination? Has discrimination taken place? They also enforce and oversee compliance programs. And I will speak about some of the compliance programs that they enforce. And they also conduct outreach regarding what laws they do enforce. And it's really important that organizations learn about what laws they have to enforce and what laws they have to be compliant with. And you're here now, so I'm preaching to the choir, but education is key. And if you don't know why education is key, here are some headlines from that have come out recently that show you people do file claims of discrimination and harassment. You never want your company to be in one of these headlines, but no organization is immune to a discrimination or harassment complaint. Now, pop quiz, we're going back into what does the federal law, the federal anti-discrimination law prohibit? Title VII of the Civil Rights Act, again, prohibits unlawful discrimination on the basis of race, color, religion, national origin, or sex. And now the recent case called Bostock that was decided in 2020, before Bostic was decided, the federal law did not protect sexual orientation. Now the federal law explicitly protects sexual orientation. So sex includes pregnancy, transgender status, and sexual orientation. DC has always had a very comprehensive anti-discrimination law in the Human Rights Act, which I'll talk about in just a second. So in DC, sexual orientation, sexual identity has always been protected. So DC has really always protected employees to the utmost extent. We are in a jurisdiction that protects so many categories, and here they are on your screen. So here are all of the laws here are all the anti-discrimination laws that are present in DC. This is why you have to educate yourself, because the laws are constantly changing. You'll see in your right-hand column just the slew of laws that were passed within the last 6-7 years. So we have the DC Human Rights Act, which protects 21 different categories. There are 21 categories of traits that you cannot discriminate or harass on the basis of. And when you think about discrimination and harassment, you often think about a really bad actor creating this terrible work environment, but you can also make assumptions about people based on their Facebook page. You can look on a Facebook page and say, oh, this person is married, they can't come to this event today. They have kids, they can't come to this event today. Let's take them off the schedule. That's actually discrimination. And we'll talk more about that in a second. But I do want you to just take a look at all of the laws that DC has in place to protect workers. The DC Human Rights Act. We have the Fair Criminal Record Screening Act. You cannot ask about a criminal record until a certain point in the interview and application process. We have the Universal Paid Leave Amendment Act. We have the Fair Credit and Employment Act. You can't ask about credit status in the application process or really ever in DC. So you really have to understand that there are many landmines in DC. If you are an employer, you can easily inadvertently violate one of these laws. What's protected in DC? We have race, color, religion, national origin, sex, age. All of the federal categories are protected, but we also have other categories. DC goes over and above what the federal law prohibits and protects. So DC prohibits discrimination on the basis of credit information, on the basis of your status as a victim or family member. So it's not just the person, the employee, him or herself or their self, it's also his, her, or their family member. Or you can't discriminate on the basis of them being a victim of domestic violence, sexual offense, or stalking. You can't discriminate on the basis of personal appearance. So if someone is wearing a shirt you don't like, that's during the interview process or while they're employed, you can't discriminate against them on that basis. In DC, across the river in Virginia, personal appearance is not protected. But if you have employees working in DC, personal appearance is a protected class. You can't discriminate on the basis of sexual orientation, gender identity, family responsibilities, political affiliation. Political affiliation is not protected in Virginia. So again, you have to know in DC, we just have an extremely comprehensive civil rights statute that protects matriculation. If someone's in school, you cannot discriminate against them or take them off of the schedule because they're in grad school or college or even high school. Speaking of which, age in DC is protected, of course, but DC protects younger workers as well as people over the age of 40. So 40 is the baseline for protection under the federal law, under Title VII of the Civil Rights Act, and under the Age and Discrimination in Employment Act. In DC, a 17-year-old is protected from age discrimination, whereas a 17-year-old is not protected under the federal law. So these are categories on the screen that you should become familiar with because your employment policies should certainly reflect these categories of protection. And not only that, but in your application process, you should ensure that you're not asking any questions during the interview or on the physical application itself about these categories. And people who are conducting interviews should be aware of what questions are just off the table, because those questions and those conversations can inadvertently create an employment discrimination claim. There are no credit checks allowed in DC. So in DC, the DC Human Rights Act, it prohibits employers from directly or indirectly requiring, requesting, suggesting, or causing an employee to submit credit information. So credit information 15 years ago, no problem. The DC Human Rights Act was amended so that credit checks were not allowed in DC in 2016. So this is a fairly recent amendment to the Human Rights Act. So if you're using template applications that are downloaded from the internet, that's really a landmine, because you might be pulling information from a state that is okay with you allowing credit checks. Virginia, again, I'll just use our sister state down the street or across the river. There's no problem using credit information during the hiring process. In DC, that's a no-no. So you just have to be careful when you're using template agreements or template documents that you find online to make sure that they're actually tailored to this particular jurisdiction. There are limited exceptions for credit checks. So when an employer is required by DC existing law to conduct a credit check, if you're required to have a security clearance, there may be a government contractor who does require that credit checks are provided to the federal government. That's an exception. If you work for a financial institution and the position requires the employee to have access to personal financial information, that's an exception to this prohibition against credit checks. And if the employer has received a subpoena or a court order requiring the credit check, then you are permitted to run a credit check on your employees. Criminal history. This is another no-no. DC passed ban the box legislation within the past about 10 years. And what that means is that you are prohibited from asking an employee about their arrest, their criminal convictions, or their charges until a conditional offer of employment has been made. So conditional offer means you are hired on the condition that your criminal background checks out. But at the outset, when you are applying for the job during the interview process, you can't ask about criminal history. And Ryan touched on this and during his introduction, pre-employment marijuana testing is not allowed. So you cannot test your employees pre-employment for marijuana. Again, it's recreational. You can't, and actually you can't test them at all now because of this requirement or because of this law that permits recreational marijuana usage. So no testing for marijuana. So what are the penalties? What are the penalties if you violate one of these statutes? Well, the EEOC and the Office of Human Rights can order back pay. They can order you to reinstate an employee if you fired them. They can request that you as the employer pay attorney's fees, which can get quite costly. They can request front pay. They can request a reasonable accommodation if there is a disability in dispute or a disability that an employee has that requires the employer to make an accommodation so that that employee can work. They can also require compensatory damages. So any damages that the employee or money that the employee has lost because of your violation, the EEOC or the Office of Human Rights can make that employee whole by giving them that money back. Employees can also go to court. I've talked about federal agencies and local agencies, but these are not courts. An employee can also go to court on many of the statutes that we've discussed. So Title VII of the Civil Rights Act, an employee can go to court after they've done what's called exhaust administrative remedies. So they first have to go to the Office of Human Rights or the EEOC, file a claim, and then they can go to federal court. Okay, they can also go with the DC Human Rights Act. They can actually go straight to court. They don't have to exhaust administrative remedies with that particular act. But I say all that to say there are some, the EEOC and OHR are not the only bodies that can award damages. An employee can go to court, and when you go to court, those filings are actually public. So the EEOC and the Office of Human Rights, most of their proceedings are private. So you're not going to have all of the factual allegations out in the public eye initially. But if an employee ultimately goes to court, your reputation can be damaged because now all of the allegations that the employee is making, they are available for the public to view. And if you're a small company, you know that your reputation is golden and you don't want your insurance to go up. You want to maintain your pristine reputation. So those public filings really can ultimately damage the company's bottom line, even if the employee doesn't get a huge judgment or a lot of money at trial, if they ultimately go to trial. Here are some questions to stay away from, some questions that ultimately come up or that likely can come up during an interview process, especially if you have a rapport with the person that you're interviewing. You want to make sure that you stay away from questions like, what's your age? What's your ethnicity? What's your sexual orientation? Your national origin? Are you disabled? Are you pregnant? I hope no one would ask these questions, but sometimes we just have to have reminders. What is your genetic information? Are you married? Which is a question that many people think is very appropriate, but it's not appropriate in the interview process. It's really not appropriate even when you have the job, even when you've extended the offer and the person is working, because these are still bases of discrimination. They're still linked to protected classes. So you have to be very careful when you are even remotely discussing these topics. And any of the 21 protected classes that were on the screen before. So harassment, what is it? Discrimination, I think we understand that discrimination is just treating someone differently. But harassment under the federal law, it's conduct that's so objectively offensive that it offers the terms and conditions of a person's employment. So it can adversely affect pay. It can be behavior that is bullying based on a protected class. It can be behavior that is intimidating based on a protected category. And the federal law, it sets a very high standard for what harassment is. It has to be objectively offensive. It has to be severe and pervasive. Federal law or federal case law has said that the law is not a civility code for the American workplace. So federal law is just tough. It does not require that the workplace is a place that is Disney World. It really does understand that there may be interpersonal conflicts at work. So it doesn't require a civility code. However, the federal law's interpretation of Title VII of the Civil Rights Act, that federal statute that we discussed, it's risky to abide by that standard in DC because DC has a much more lax standard, a lower standard for harassment. In DC, the DC Human Rights Act, which was actually recently enhanced, and those enhancements go into effect tomorrow, it shall be unlawful to engage in harassment based on one or more protected characteristics specified in subsection A, including sexual harassment. So those protected characteristics are those 21 that were on one of my previous screens. So you cannot harass based on those categories. Let's go further into what harassment looks like in DC. So it's conduct, and it can be direct or indirect. It can be verbal or nonverbal. It can be a gesture, And it has to unreasonably alter an individual's terms, conditions, or privileges of employment. And it has the purpose of creating an intimidating, hostile, or offensive work environment. So something that's offensive to me may not be offensive to you. However, this is a standard of reasonableness. Who is reasonably interpreting the conduct? And that's ultimately an issue for a court, the Office of Human Rights to decide. But you want to err on the side of caution because the standard is reasonableness. And everyone has a different barometer for what's offensive, what's hostile, or what's intimidating. Now, what is sexual harassment? We've heard that term just recently in 2018 during the Me Too movement. We heard that term a lot. Sexual harassment is something that DC takes very seriously. And sexual harassment is defined differently under the DC Human Rights Enhancement Act, again, which goes into effect tomorrow, than it is under Title VII, which is the federal statute. So in DC, sexual advances, so sexual harassment is harassment. The key term is of a sexual nature, and it can be requests for sexual favors or other conduct of a sexual nature where submission to the conduct is either explicitly or implicitly a term of condition of employment. So that's what's called quid pro quo sexual harassment. Someone says, hey, you go out on a date with me, I'll give you this assignment you've been looking for. It's going to help with your promotion. That's explicit quid pro quo sexual harassment. It's a favor or it's a benefit that someone's getting in exchange for a conduct that's sexual. Now, the conduct can be a submission or rejection of the conduct is used as the basis for an employment decision. So if that employee who was offered that date said, no, I'm not going out on this date with you, and then the person took away that particular project, well, now we have, again, that sexual harassment. It's a quid pro quo type of sexual harassment, but nonetheless, it is a form of harassment. And we'll go into what the requirements are. We'll go briefly into what the requirements are for certain industries. They now have to be trained on sexual harassment. The restaurant industry or the tipped worker industry is an industry that now has to be trained under the Tipped Workers Fairness Amendment Act. So I'll talk about that in just a bit. So going beyond what federal and local laws require, I've talked about the baseline of what's prohibited under federal and DC law. You should really focus on what's prohibited under DC law because that incorporates the federal law and sets a much more comprehensive list of prohibitions than the federal law does, but incorporates that federal law. So how can we create a respectful workplace as a part of our anti-harassment strategy? So when a company has had a lawsuit filed against it, I've talked a bit about this, but it is a very uncomfortable place for a company to be. You have to speak to employees. You have to investigate the claim. If you have a small organization, this really can disrupt your company morale. So you have to think about, hey, what are the reputational damages that my company is going to suffer by an employment discrimination or harassment lawsuit? How is this going to affect my company's morale? What about the cost of defending this? Even if we don't have to pay this employee, how much is it going to cost to actually defend this claim? Companies that don't have employment practices liability insurance should certainly consider it because lawsuits are expensive. Employment lawsuits are very, very expensive. They require discovery, which is an information exchange, the production of documents, interrogatories, depositions. All of those things take time and money away from the organization. And lastly, time. It takes a lot of time to defend these claims. Claims can hang over a company's head for years. And if you are a small business, you want to be focusing on serving your clients, serving your industry. You do not want the CEO or the owner or the head of HR sitting in depositions for a day, preparing for depositions, collecting files, being subjected to interrogatories. You really want your company to do the thing that gives you joy, and that's not defending a lawsuit. And Ryan says lawsuits take away from the substantive work of the company. Definitely. So how can we make sure the substantive work of the company is being done? How can we create this legally and this compliant culture, but also this inclusive culture? Well, one, having respect as a common thread for successful relationships and for a successful inclusive culture is crucial. It is crucial to have respect as a core value in your company. Many, many lawsuits are filed because people don't feel respected. Now, nowhere have I put in this slide, in this presentation, that you are required to respect your employees. However, if you constantly walk by someone every day and they never say hello, that actually could feel like disrespect for some people. I know for me, I'm from the South. I like saying hello to people. When I go to certain areas of the country, no one says hello. I feel very disrespected, but I understand that that's just, that's a cultural difference that I have from other geographic regions based on where I'm from. But respect looks different to various groups. So having respect as a core value, talking about what respect means to each and every person within the organization is super, super important. So create that culture of respect, define what respect means to your organization. Does it mean supporting each other? Does it mean not yelling at each other? Does it mean having transparent conversations? Talk about what respect means. Values have to start from the top of the organization and then emphasize throughout the organization. So the CEO has to emphasize that respect is a core value and walk the walk and talk the talk, not just one, but everyone within the organization has to make sure that they are actually exhibiting and manifesting the core values that you decide upon. Managers, supervisors, employees, everyone. Take ownership of these values. So making sure that you reward people who do exhibit these values that you discuss. Really, really important. If there's a culture of not yelling at each other, of making sure that you support each other, it's going to be very hard to show, hey, someone was harassed based on one of these protected categories, because we have a core value of 1, respect, 2, supporting each other, 3, not yelling at each other or using abusive language towards each other. Respect has to be that centerpiece, and you can define what respect looks like. And then finally, make sure that you encourage employees at all levels to report incidents that violate the company's values. So not just violating what the law says you have to report or what the law says is prohibited, but also violating the company's values. That might include a legal violation, but it may not. So if a person feels that they're not being respected, encourage that employee to report and have a reporting system for doing so. And I'll talk about that in just a second. So the EEOC has created a checklist, which is meant to be used as a tool to think about your company's anti-harassment strategy. So some of the things that the EEOC has recommended that companies do is conduct climate surveys to determine whether harassment is actually a problem, adopt an anti-harassment policy, which considers social media considerations. And as we've gone virtual, this is even more of an important consideration to be had. Harassment happens on Slack. Harassment happens on Facebook. The workplace is not in the office anymore. It's everywhere. So defining what harassment looks like in virtual settings is really important, and especially on social media platforms or whatever platforms your company uses. Offer compliance training, compile resources that contain checklists so that you can make sure that your company understands, your company managers and your people leaders understand what compliance means, what it looks like, and what has to be done to be legally compliant. And then conduct respectful workplaces training. And let's see, Ryan, I will address your question. You have a question. Can you explain when the EEOC gets involved in a claim versus DC human rights versus courts? Yes, I'll explain that at the end. Okay, special training and reporting requirements for certain industries in DC. Now, DC recently enacted the Tipped Wage Workers Fairness Amendment Act, the TWWF, and it requires DC employers who hire persons earning tips as wages to inform their employees about their rights and benefits. So this law also requires that these companies provide training. It cannot be a pre-recorded training. It must be live. And if you are a manager, you have to attend an in-person training. So this particular seminar would not constitute an in-person training. The trainer would actually have to be in person in the way that we all understand it before the pandemic. There are also specific reporting and training requirements under this law. There's a deadline to provide reports of harassment to the Office of Human Rights. The Office of Human Rights also has to receive from companies their employment, their anti-harassment policies. So their posting requirements. There's several requirements that employers who engage and employ tipped wage workers have to abide by. You also have to be trained by a certified trainer, and the Office of Human Rights has certified one cohort of trainers for the Tipped Wage Workers Fairness Amendment Act. I am proud to be in the second cohort of people who are applying for certification. And so within the next month, I hope to be certified as a trainer under this act. If you are a restaurant, please reach out to me within a month and I would be happy to talk to you on whether I would be able to provide your training. There's also the Care for LGBTQ Seniors and Seniors with HIV Amendment Act of 2020 that was passed recently. This requires training for the staff of long-term care facilities. So these are specific trainings that DC requires for these two industries. The Office of Human Rights, I've been in communication with them. They are currently putting together the qualification requirements for training under this Care for LGBTQ Seniors and Seniors with HIV Amendment Act of 2020. So companies are not yet required to provide this training, but long-term care facilities will be required to provide this training once that certification list has been completed. So what should training look like? Even though the two industries that I have here, DC requires these industries to be trained, all industries should be trained. There is a lot of content that we've discussed already. And if you are not aware of, as a manager or as an operator of a company, what your legal requirements are in DC, you really could be stepping into a landmine. So it's important that all industries are trained. So here are some things to consider. The training should be supported at the highest level. It should be repeated on a regular basis. You really should have annual training. It should be completed by all employees, conducted by a qualified trainer. It should be live and interactive. Of course, there are pre-recorded trainings, but people should have the opportunity to feel engaged and to take ownership in that training so that it's not just a check the box training. If the training is not live, it should be designed to include engagement and it should be evaluated. So these are just a few considerations that you should make when you're putting together your actual training or contacting a consultant to provide training. Again, it should be easy to understand, provide clear instruction on how to report harassment, because many harassing incidents happen in the workplace. And it really is a gut punch to employers when they have no idea, but they receive that charge of discrimination from the EEOC or the Office of Human Rights, and they have 30 days or however many days to respond to that charge. So we know that workplace incivility often acts as a gateway drug to harassment claims. And that is so true. Incivility or a lack of respect, that is often what causes people to go to the EEOC. So it is the golden rule: treat others the way that you want to be treated, or treat others the way that the company has determined that people should be treated within the organization. But you have to have a code of civility, even though Title VII has been interpreted not to be a code of civility. So here you have the EEOC saying workplace incivility often acts as a gateway drug to workplace harassment. So we know civility is so important. And the EEOC has also stated that they believe that effective training can reduce workplace harassment. And they recognize that ineffective training can often be unhelpful or even counterproductive. So you really want to have an effective, robust, engaging training program that people feel inspired by, and that people feel that they actually own and they can actually effectuate within the workplace. So company culture matters to employees. We've all worked within organizations that either we are the owners of or that are owned by someone else, but we all work with people, and culture matters. So 50%, 52% of human resources professionals believe that buy-in from management is the largest challenge to creating a better workplace culture. We know that if our bosses don't buy in, then our anti-harassment strategy is really null and void. We have to have leaders who buy into the anti-harassment strategy. 42% of employees think that executive leadership does not support a positive culture. So we have to change that. And the people leaders on this call, you all really do bear that responsibility of showing that executive leaders do support a positive culture. 52% of employees agree with the statement: our internal office culture creates a lot of barriers to exercising good ideas. And 80% of companies plan to improve their culture. So with these statistics, I hope that you are motivated to be in the category of people that are creating that inclusive culture, so that your employees say, no, my executive leadership does support a positive culture. We have a great culture here. We have a respectful workplace. I have never felt discriminated against or harassed, and I love working for this company. With that, I'm going to allow you to ask me questions. I know Ryan has one question, and while I answer his question, if you want to put your question in the chat, I would be happy to answer it. I think we have about 8 minutes, so I'm going to quickly go through these questions. Let's see, Ryan's question is, can you explain when the EEOC gets involved in a claim versus DC Human Rights Office versus courts? Yes. So you in DC can file a claim with the DC EEOC, or it's the federal EEOC office, the DC field office. They cover Virginia. Northern Virginia. There's also a Richmond office, but in Northern Virginia, DC, if you're in Montgomery County, you're going to Baltimore, the Baltimore EEOC office. But in DC, your claim will be fielded to the DC field office. You have to file a claim under one of the statutes that the EEOC enforces. Okay, so the EEOC does not enforce the DC Human Rights Act. The EEOC enforces, I'm a visual learner, so I'm going back to my slide about Title VII. Let's see. Apologies. Here we go. So the EEOC enforces Title VII of the Civil Rights Act. also enforces the Pregnancy Discrimination Act, the Age Discrimination and Employment Act, the Americans with Disabilities Act, the FMLA. DC has its own FMLA, the DC FMLA, which is actually far more comprehensive than the federal FMLA. The requirements are less stringent under the DC FMLA if you're an employee. But my point in saying that is that the EEOC enforces a prescribed number of laws. So you have to get into federal court, the DC District Court, you have to first file your claim with the EEOC if you want to go to the DC District Court. You have the EEOC will investigate the claim. They do often offer parties the ability to mediate the claim. Both parties have to agree to mediate in order for mediation to take place. If one person says no, if one party says no, we're not mediating, mediation does not take place, and the case then goes into an investigation by an EEOC investigator. During that investigation, the EEOC may ask for documents from both the employer and the employee. The EEOC may come out to your work site and do an investigation there, interviewing employees, asking for additional documents. They will ask the employer to prepare a position statement, and that position statement has to respond to the employee's allegations, those allegations that were made in the employee's initial complaint. That investigation process by the EEOC can take over a year. So it's a long process, and you may not hear from the EEOC during that investigation process. Once the investigation is complete, the EEOC can make a finding that discrimination has occurred, and they can offer to conciliate the claim, meaning they can offer a settlement of sorts that the employee has to accept. They have to agree to the proposed settlement that the EEOC has proposed. The employee can say no. The employee can say, no, I'm taking this case to court. And the EEOC will say that's perfectly within your right. Here's your right to sue letter. And the EEOC can also say, hey, we're not conciliating. We're not doing anything with this claim. Take this to court. Here's your right to sue letter. That right to sue letter is essential. It's a requirement to getting into federal court. You have to have a right to sue letter. Now, once you get that right to sue letter, the employee has 90 days, that's a strict 90 days to file a case in federal court. If they don't file within 90 days, that case is dismissed, gone. There's no recourse for the employee. Okay, so that's the EEOC process. Office of Human Rights, similar but not the same. In the Office of Human Rights, with the DC Human Rights Act, you can go straight to court. You don't have to exhaust your administrative remedies with OHR. You can go straight to court. Or you can go to the Office of Human Rights, which is often more cost effective for an employee because the Office of Human Rights is doing all the work. They're doing the investigation, they're offering mediation, there may be a hearing, but there's a specific amount of time that you have to withdraw your claim from the Office of Human Rights if you first file with the Office of Human Rights and then want to go over ultimately to the DC Superior Court. So with the Office of Human Rights, if the Office of Human Rights conducts a hearing, if they make a probable cause determination, you're no longer able to pull that case and go to Superior Court. All right, so I hope I've given you an overview, and I want to be respectful of time. We have 3 minutes. Linda says, can a person claim discrimination if they are not referred to by their pronoun? Thank you, Linda, so much for this question. I actually had a whole set of slides on this topic, and for the sake of time, I did not present them. But yes, gender identity is extremely important. It is a protected category in DC. You do have to be respectful of pronouns in DC. And so if if an employer continually uses the wrong pronoun to refer to an employee, then there is a potential claim for gender identity discrimination or gender expression discrimination or harassment. So this is extremely important. This topic is actually, I believe, going to be one of the topics that the new Care for Seniors Act requires training on. And so this is, I think a lot of people really need, and organizations really need training on this topic of proper pronoun usage. So thank you so much for bringing that question up. And let's see, Ryan's comment, the employer then cannot retaliate against the employee for taking their complaint to the EEOC or to court within 120 days from a finding, or yes, 90 days. So Ryan, thank you so much for your comment. Retaliation, and I had another slide showing how many cases of retaliation are filed each year. And again, for the sake of time, did not show you, but I will tell you, once someone engages in protected activity in general, that means once someone has actually filed a complaint based on any of the civil rights that I've discussed, they can file that complaint internally with HR, they can file it externally with one of the agencies we've discussed, they can make an oral complaint to a manager. So a filing doesn't necessarily have to occur. When people hear the word filing, they think of, I'm going to court, I'm putting together this formal document. That's not the way that protected activity occurs in real life. In real life, someone can make an oral complaint, they can make a written complaint, it can be an email, it can be a text message. Hey, someone's using an improper pronoun for me. Hey, someone is harassing me on the basis of my sex by continually asking me out on a date. Someone's made an improper gesture towards me that made me feel uncomfortable, and now I'm not getting the assignments that I used to get. These are all protected acts, they're protected complaints, and you can then not retaliate against the person making that complaint based on their engagement in that protected activity. That's essential retaliation. That's casebook retaliation. You can't act in an adverse action towards someone for making a complaint. So it's not just going to the EEOC. That's not the only protected act that someone can engage in. That's an obvious act of protected activity, but some of the less obvious acts of protected activity are making an oral complaint to your manager to say, this is happening to me based on my protected category. Okay. I'm going to finish up now because we are at the 1 o'clock hour, but before I do finish, I would like to just give you my contact information. Feel free to take a screenshot of this information. I would love to talk to you about how I might be able to help your team by training your company or walking you through some compliance issues. So please take a screenshot, please contact me. I would love to speak with you further. And I very much thank you for your time and attention this afternoon.
Jessica Childress, Attorney Childress, thank you so much for participating. You put on a wonderful presentation. I know we've all been enriched by your presentation, and I look forward to sharing this in the future, not only internally at the chamber, but with our membership, so that this is a presentation that doesn't just reside here, but lives on into the future, because what you did prescribe here in this presentation is how employers should behave. You give us a lot of nuts and bolts to, what the background is for an employer to cultivate the proper organizational structure and environment to avoid certain issues, and it's invaluable. And so I want to also thank the DC Chamber of Commerce. I want to invite you back to come out to some of our events that we're having with the DC Chamber of Commerce. And so we want to stay in contact with you. And I hope you wouldn't mind making your presentation available to Natalie Harris here, who is overseeing a lot of the human resource components of the DC Chamber of Commerce. This could be a wonderful resource for her.
Excellent.
And so I would love to stay in contact with you. The chamber really appreciates you. And thank you so much. Have a wonderful afternoon and a great rest of your week.
Thank you, everyone. Thank you, Ryan.
Thank you, everyone. Have a good one. Thank you, Jessica.
Bye.